Well, hello and welcome back to my channel. My name is Joanne. I am the Lunar Lawyer. So we got a filing. It's sort of gone under the radar because a lot of people are caught up in the Johnny Depp Amber Heard case. And so, um, you know, they're caught up in that. And so this filing's just sort of slipped under the radar, but we can have a look at it. I've read it a couple of times. It's taken me a couple of times. I'm hoping this third reading, it might actually make sense. Yeah, we'll just see, and then we'll see what you think. I'll give you my opinion on it. Not that it counts for anything, but I'll tell you what I think. And then you can tell me what you think in the comments below. So it's Saturday night. It's about 11:19. It's on the 20th of May. We're about to hit the 21st of May, probably by the end of this. And it's election day, big day in Australia. So I'll try and make this as large as I can as we read through this. Now, this is 4 pages long. So it is a reply memorandum in support of defendant's motion to dismiss. So this is what we've got. Plaintiff's claim all revolve around alleged statements made by defendant Paulson and claims alleged to have flowed from those statements. Because defendant's statements do not meet the legal standard for defamation, both plaintiff's claims regarding the alleged defamation itself and claims stemming from the alleged defamation should be dismissed. Case law, the rules of evidence, and the full record currently before the court supports defendant's position that plaintiff's claims should be dismissed with prejudice. What a word salad! Revolver made by defendant Paulson and claims alleged to have flowed from those statements. Because the defendant's statements do not meet... Huh? Okay. Yeah. So they're saying that what she said isn't actually defamation, which I find to be really bizarre. Anyway. I told you, this is the third reading and it's still not making any sense. Argument. Defendant's alleged statements do not meet the requirement of being false and made with actual malice necessary to be actionable. The fact the plaintiffs are public figures is an indisputable fact of which the court can very appropriately take judicial notice. Minnesota are evidence 201. Public figures are subject to vigorous attack. They must show actual malice, which is not what it sounds like. Rather, for a public figure to recover a claim of defamation, he carries the burden of proving the alleged lie was a knowing one or uttered in reckless disregard of the truth. New York Times in Rose versus Koch. Here's my question. The defendant, Paulson, actually hasn't proved... I don't remember her putting together a claim that they were public. Like, she said they were public figures, but I haven't seen any proof for her to say why they are public figures. I don't think... Yeah, I mean, there's been no... When determining a motion to dismiss, the court take the alleged fact in the complaint as true. So that's right. When determining the alleged in the complaint as true. Plaintiffs have failed to point to any facts in support of their claims that actual malice exists, and based on the public figure exception, they will not be able to find that such facts sufficient to support any of their pleaded causes of action. Plaintiffs have made no argument that the defendant made the alleged statements in reckless disregard of the truth. This position is further bolstered by the fact that defendants are not alone in this line of reporting. Oh no, here we go. We're going for the... But everybody else is saying it. As previously noted, many other news outlets have reported on the same or similar allegations regarding plaintiffs, their business practices, and treatment of their managed talent. Since following the defendant's motion to dismiss, even more reports regarding plaintiffs have emerged, with HBO and Chrissy Teigen announcing they are creating a docuseries based on the plaintiffs and these same allegations. With the wide coverage of the plaintiffs' business practices, plaintiffs cannot show actual malice in defendants' reporting and statements. Actually, here is the thing. This is my thoughts. What if some of these, so she's saying that HBO are creating a docuseries. What if it was what she said that created the fact that these people are now creating the docuseries? How do you prove that? I don't know. But that would be my argument. If 7M's watching, that would be my plan of attack. It's funny that she's saying that there's all these things that are happening since she filed the motion to dismiss, but were they interested before she started spouting on about it? Or was it the fact that she called them a cult? Or was it the fact that she said that they were involved in human trafficking, allegedly? Well, we know that she said that they were doing human trafficking, and that is actually in the complaint. If you actually read the original complaint, you see about human trafficking. So, and she said that they were a cult. She said that they, were, yeah, we know what she said. So, yeah, but anyway, what if from what she said, these other people interested? Anyway, with the plaintiff's series of defamation claims properly dismissed, plaintiff's claims stemming from the alleged defamation should be dismissed. But hang on a minute. I'm not seeing anything here that tells me that. So she's saying they can't show actual malice. So she's saying they're public figures. It's obvious that they're public figures without giving proof that they're public figures. She's saying that you can't prove actual malice because all these other news outlets are doing it. Well, that's not a defense. Anyway, but again, they've not gone against the claims. They have not gone and said tortious interference. They've not addressed the claims. With plaintiff's series of defamation claims plaintiff claims stemming from the alleged defamation all cite the alleged defamation as the basis for the claim. Amended complaint 6283 1995 105. While most of the claim stemmed directly from alleged defamation, plaintiff's claim of intentional infliction of emotional distress isn't even based on defendant's behaviour, but rather on the behaviour of others plaintiffs seem to guess are motivated by the defendant's statements. Hello. One of the tests of defamation is that it's said to somebody else. And don't forget, there was also tortious interference of business, which is based on what she says anyway. Defendants' alleged statements do not rise to the level of defamation, and therefore these claims fail. It's funny how they're saying alleged statements. She never once said alleged in any of that. Further, regarding the claim to intentional infliction of emotional distress, specifically with a multitude of news stories regarding plaintiffs. Plaintiffs cannot make a showing that defendants' alleged statements were extreme, outrageous, or cause of any distress of plaintiffs are currently apparently experiencing. Defendants' alleged statements cannot be deemed extreme or outrageous when she has simply reported on the same stories as Rolling Stone and now Chrissy Teigen, HBO, and others have reported on their vast audiences. With this abundance of media attention, but don't forget, she did it first. In addition to plaintiff's own sought-out celebrity, it is impossible for plaintiffs to prove these alleged actions of third parties, or any attention plaintiffs are receiving from third parties are in any way directly related to the defendant. Because there is no possible way for plaintiffs to connect defendants' specific alleged actions to alleged conduct of third party. This claim is consequently not actionable and should be dismissed. Well, it is if you can prove that there has been, because of her Instagram, that her fans went and contacted the company. For the foregoing reasons, defendants respectfully request the court grant their motion to dismiss for failure to state a claim on which relief be granted and dismiss all claims with prejudice. To me, that is actually not a very well written document. They've not addressed anything. So it's everybody else is doing it because everybody else is doing it. Everybody else is doing it, so therefore you can't prove it was me. So I'm stating that if she started the allegations and then everybody else has started, you could actually state that she did actually rile up all these people to start this harassment on them. So that is their reply memorandum support of defendant's motion to dismiss. That was in response to 7M's thing. This is poorly written. I'm actually this is actually very embarrassing. Because I mean this first paragraph makes no sense. This case law, the rules of evidence, and the full record currently before the court. They mentioned some case law, rules of evidence. There's nothing here about rules of evidence, and there was no reference to any of the record currently before the court. Because the defendant's statement do not meet the legal standard for defamation. What's the legal standard for defamation? You have to put it there. So let's just go to this. Defamation meaning in Minnesota. So let's have a look. So we're going to go to the statutes, or as somebody else has said, statutes. Okay, this is criminal defamation. Is there we haven't got to criminal defamation, but criminal defamation. So we want to look at, actually, you know what I saw when I did it? Aaron Hall, Aaron Hall has done defamation. All right, here is the rules. So she says here, because defendant's statements do not meet the legal standard for defamation. So let's have a look. The statement was communicated. So in the defamation, the plaintiff must establish that defamatory statement contains the following three elements. The statement was communicated to someone other than the plaintiff. Did the statements that Katie Joy make communicated to somebody other than 7M? Yes. The statement was false. Allegedly, yes. The statement must tend to harm the plaintiff's reputation and lower him in the estimation of the community. Yes. So we've met the elements of defamation. A defendant is negligent if he or she, or if he knew or should have known in the exercise of reasonable care that the defamatory statement was false. Negligence is more likely than not a standard of liability. This standard is applied to claimants who are private individuals. On the other hand, a claimant who is a public official or public, such as a celebrity, must overcome a high burden of proof standard, is actual malice or reckless disregard of truth. So, did the defendant, Katie Joy, know or should have known in the exercise of reasonable care that the defamatory statement was false? Possibly. Now, here's the thing. These are the common defenses. The common defenses to defamation. And she's not used any of them. Truth. Substantial truth. A claimant will still not prevail if the statement is substantially true, despite some minor false or inaccurate information. So the truth is a true statement, even if defamatory, is an absolute defense against defamation. In Australia, you actually have to prove that is true. Statute of limitations, so 2 years. So is it within 2 years? Qualified privilege. Examples of privileged speech include statements in official reports, professional reviews, an employer's response to an unemployment claim, workers' compensation claim. It's usually invoked in an employment context. Retraction statute can be a defense for a newspaper or other media outlets that have published a defamatory statement. A retraction. So she would have to do a retraction. Opinion defense. So, however, one must be careful about what they do as an opinion. Minnesota also allows for general damages such as emotional and mental distress and loss of reputation. Minnesota also allows for special damages, which is usually an economic loss that is quantifiable. In defamation per se cases, punitive damages are also allowed. And then we've got criminal criminal defamation. So that is, so I would say, because do not meet the legal standard for defamation. I would argue that according to Aaron Hall, who was her 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 lawyer for a while, we can meet the burden of proof. Now we also know that in Minnesota, you only have to state that you don't actually have to prove in the plea at the initial stage that they are defamatory. You only have to state that they are defamatory. So that will all come out in discovery. It's a little bit interesting how that happens. But look, I want to know what you think. I want to get your opinion on this document. As I said, hey, I'm just a learner lawyer, but I think, to be honest, I could have written it better. I don't understand the format. Australia has a different format, of course. But one of the things that it's drilled into us, even at this early stage, is that you have to give examples. So if they're saying isn't based on defendant's behaviour, but rather on behaviours of alleged do not rise to the level of defamation, and therefore these claims fail. Where's a case? Where's an example? Where's a case law example where that's happened? With the multitude of news stories, they cannot make a showing of where's a news story that says that backs up that statement? Where's a news story that says that if there's multiple stories on the one thing, where is it? Where's the evidence? Where's the proof? Where's the proof? Everything has to be backed up, and if you can't back it up, then you don't say it, or you come up with a way that you can say it, that you can back it up. There are hundreds and hundreds of cases all around the world. Surely somebody has done, challenged it in court. But yeah, what I liked about even, is that you make a state like here, they've done it. And the court takes the facts in the complaint as true. They've just, in the complaint, in the original complaint, which is the 7M complaint, as true. Yes, that is true. And they've given case law. They've actually proven 7M's point. So, yeah, he goes. So that's what I, have made no argument that made the alleged in the reckless regard of truth. Some of that stuff is reckless regard of truth. We've seen it. So, yeah, I'm interested in this one because this is interesting. See, for me, this since filing the defendant's motion to dismiss, even more reports regarding plaintiffs have emerged, with HBO and Chrissy Teigen announcing they're creating a docuseries on the plaintiffs with the same allegations. Remember, some of those have mentioned that she's been sued for defamation on what she said about them, where some of these other outlets won't even mention the cult word and won't mention, or have done it very cleverly, or have given both sides of the story. So anyway, I need to probably head to bed. I've got an early start in the morning. I've already voted. I've done my deed, done my civic duty. Yeah, we'll see what tomorrow may bring. Tomorrow is going to be a historic day, in one way or another, and we will see what comes of it. Make sure you hit like and subscribe. I'm interested to see what you think about this. It's a very hard. They shouldn't be very long to read. They should be very clear, concise, to the point. I know some of the stuff that I've been told is some of my stuff's very long-winded, and I've got to cut it down. But the backup or the case law or the statute law is really good, because I'm actually writing something at the moment where I've got to look at the Charter of Human Rights in Victoria with the child Protection Act with with 3 or 4 acts of parliament and trying to give advice around all of that. So, it's quite difficult. But anyway, that is the latest on Katie Joy. Now, I had another theory about the Instagram thing, because people are saying, how would they have memorialized her? So my theory was that Instagram had some legal action and they froze it or memorialized her Instagram account so that she couldn't delete anything. But I think that she knew. I think she was told that that's what they were doing. And so the cover up about the hackers and the trolls is just a cover. I just don't know. But as I said, that's just my opinion. Don't hold me to that. I've really got no idea. I really got no idea. I'd like to know, but I don't know. Anyway, as I said, I'm going to go now. I thank you for watching, and I'll catch you again next time. Bye for now.